actions businesses will need to take. But that's why we're here, to cover a summary of those actions that you need to plan for. So why is there so much this year? Well, it's partly due to the employment law changes that the government have been making since Brexit, and the workplace agenda, which really seems to be much more focused on well-being, mental health, and flexibility in the workplace. However, don't worry, Park City has you covered. Whatever support you need, we are here to help business owners and directors. And if you're a client of Park City, hello. But rest assured that your HR business partner will be going through these changes with you to identify the specific actions that you need to take within your business. If you're not a client, please do get in touch today and we will talk you through how easy it is to sign up and become a client, taking all this stress and worry off your shoulders. And at the end of the webinar, we've got some really great offers for you, so do stay tuned for that. Okay, looking now at the industry sectors that we've got logged in today. So you can see the pie chart there. Well, we've got over 100 of you that I can see on the attendee numbers that are logged into the webinar today, which is fantastic. I can see we have clients logged in. Hello to you. We've got some non-clients, some business owners, directors and managers. Welcome to you too. And we have got lots of value for all of you. So a very warm welcome to you. You're all really welcome and it's great to see you. Okay, so the sectors on the screen at the moment, or that were on the screen, sorry, Izzy, the sectors that are on the screen at the moment, this pie chart shows all of you. So these are the sectors that you all come from. And it's interesting because these sectors are actually very representative of our client base. So the people that have logged in are also representative of the clients that we have on retained HR services. But I've been told I've got a very tight timescale to stick to. So without any further ado, let's crack on with the list of employment law changes. Okay, so you can see we have a roadmap for you. Do have a look at that because half of the roadmap we are going to be covering today. And then the other half we're going to be covering in the second webinar, which we plan for the spring, so maybe in a couple of months' time. But here's the list we're covering today. Working time and holiday, lots of changes. The right to work checks for illegal workers, these have changed significantly. National minimum wage and national living wage, everything's going up, of course. Holiday for irregular hours workers. A brand new carers leave. That's a new piece of legislation just to keep us on our toes. Flexible working, lots of changes. Redundancy and family-friendly rights. I did say at the beginning, very much the agenda from the government is flexibility in the workplace and making sure that, you know, we're very family-friendly, and also some changes to paternity leave. And then you can see in the second half of the roadmap, kind of July onwards, a whole bunch of things that we'll cover in the next webinar, which is a load of changes to TUPE, new rules on tipping, harassment, which is a new responsibility for employers that is quite onerous, neonatal care, and a whole bunch of other things that you can see listed. Okay, let's dive in then to working time regulations and holiday changes from the 1st of January 2024. So the Employment Rights Amendment, Revocation and Transitional Provision Regulations 2023. That's a bit of a mouthful, I can tell you. So following Brexit, the government has made a number of announcements about the changes to the working time regulations and TUPE. Now, there's new guidance to cover the latest holiday pay and entitlement reforms. So if you remember, during COVID, the government brought out a new regulation to allow holiday to be carried over, okay? Because during COVID, it was quite difficult for people to take holiday. However, from the 1st of January this year, the COVID holiday carryover has now been removed. So what this means to you as a business owner and director is that Any carryover of holiday from COVID, the employees need to take that by the 31st of March this year. Now, before you start asking, can I pay in lieu? Unfortunately, you can't. You can't pay in lieu for that carryover holiday. The reason that you can't pay in lieu, this is all about encouraging employees to take their holiday. And the working time regulations, as you know, were introduced for that purpose. And to kind of support employees with their working time, rest breaks, holidays, etc. And of course, as you all know, is part of a good health and safety practice to make sure that staff are taking their holidays and getting the rest, etc. that they need. Now, the other change to the working time regulation is the removal of the requirement to keep daily records of daily working hours. As long as, there's always a caveat, as long as you can demonstrate that you're complying with the weekly working hours limits. Okay, so what's our recommendation? I'm really sorry, but our recommendation is really you've still got to keep records. You've got to keep your own records of working hours, particularly for HR reasons and health and safety reasons. So, for example, if you had an accident at work claim from an employee, they said they had an accident in the workplace. If you haven't got records to fall back on to identify were they actually at work at the time they said the accident took place, it's really difficult for you to defend yourself. Now, the good news is that Park City partner with Breathe HR software. So this record keeping requirement is easy for our clients because when they're using Breathe, that will assist with record keeping, document storage, logging health and safety incidents and accidents, and of course, keeping up to date training and briefing records. Now, as you know, the other point on holidays here, as you know that the holiday rules state the entitlement of 28 days in the year for a full-timer. That's a requirement. So, and they need to be taken in the year. It is illegal to carry over holiday. However, 1.6 weeks can be carried over if there's a contractual agreement to do so. So let's look at your action points on this slide. Written agreements for your employees, if you want to carry over any holiday, must have a written agreement in place. Updates to your HR policies as a result of these changes, and of course, briefing your managers, making sure that they understand the changes in legislation, changes in process, and what actions they need to take. Please talk to us. We can update the policies, write all the briefings, prepare everything for you, nice and easy. Risks. What if you don't do it? If you think, well, if I take no action, what happens? Very likely you'll get grievances, and of course, health and safety wellbeing claims. You know, we really don't want to be defending those. Let's move on then to right to work checks. Now, this came in this month, these changes. So the right to work checks came in on the 13th of February. It's the Illegal Workers Referring to Immigration, Asylum and Nationality Act, amended by the Immigration Act. So it's now in force, okay? And what has happened is that the fines for employers that are found to employ illegal workers have increased significantly. In fact, they've tripled, okay? So if you get found that you're employing an illegal worker, for your first breach, okay, the employer, the fine has increased this month from 15k to £45,000. Okay. Repeat breaches after that, the fine has increased from 20,000 to 60,000. This is per illegal worker. Okay. Now, what we want to avoid at Park City is a genuine business getting caught out by this, okay, through just not knowing the rules or not applying them correctly. As an employer, you need to check all workers have the right to work in the UK, ideally before you employ them, certainly as a minimum by the first morning that they join. Now, you do still hear of employers only checking workers with foreign sounding names. Now, that is potentially discrimination. And importantly, perhaps more importantly, you could miss potential illegal workers taking that approach. So all workers do the same rights to work checks. The regulation states that the employer must either do a manual verification. This is the passport. So you check the physical document. Does it look and feel to be real? Does the photo look like the individual? And the name and date of birth, do they match all the other records that the employee has provided? Now, a common misconception here is that you can use driving license, but you can't. Okay, you can't use that. That's not acceptable for right to work checks. Other alternative is identity document validation technology. This is a portal or a provider that checks the right to work for you. Obviously, there'll be a cost attached to that, but there are providers that do it. Or a Home Office online validation. This is where the employee goes into the Gov website, gives you, the employer, a share code for you to validate on the Gov website their right to work. Now, it doesn't end there. This right to work check has to either be printed or you have to save the record to confirm that you've done the right to work check and hold those records for a period of time. Now, we're here to help with this. We can review or set up your HR processes with a right to work checklist for managers. We can do an illegal workers review for you and provide the process and system for record keeping. If you're a client, we will go through the review with you as part of your service, or you can upgrade your service to include employment law reviews, meetings, etc., where we can come in and do the manager's briefings for you. Again, the Breathe HR software will help you with storing all your rights to work checks, your HR policies, and be used to communicate all of the policies to the employees and make sure that they've read them and understood them. So look on the screen, what are the actions you need to take? Recruitment policies, other HR policies and processes need to be updated, checklist for managers, and brief your managers on what to do. It's no good just having the policy sitting in a handbook or away on a share site somewhere and no one refers to it and the managers don't actually know how to apply it. It's really important that we brief the managers. What are the risks here? Well, hefty fines. I've just gone through those. You could be fined 45,000 or more, so it's no laughing matter. Let's look at national minimum wage now. And move on to the next slide. So this is something that you've got a budget for. If you pay national minimum wage and national living wage, from the 1st of April, these are all going up. This is effective, obviously, for 6th of April pay packets. Now, the living wage, the age band will be expanded to include workers aged 21 and over. The national living wage for people over 21 and older, this is going to increase 9.8% from £10.42 to £11.44 per hour. The national minimum wage for workers 18 to 20 will increase 14.8% from £7.49 to £8.60 per hour. And the young workers rate for workers aged 16 to 17 will increase 21.21% from £5.28 to £6.40 per hour. Okay. Now, the apprenticeship rate, this is for apprentices under 19 or over 19 and in the first year of their apprenticeship, will increase from £5.28 to £6.40 per hour. So actions on this slide for you. Employers, you need to budget, of course, for the increases. You need to inform payroll. You need to update your contracts of employment, obviously with the changes in pay rates. And if you don't want to update the contracts, then you need to do an addendum to the employee's existing contract. Now, please remember that a written contract or a statement of employment particulars must be provided to your employee by law on or before day one of employment, unless you want to go to tribunal, which obviously you don't. So please get in touch. We can help you write those contracts, of course. And what are the risks here on the screen? Breaches for failing to pay this include fines for the employer of up to 20,000 plus a minimum of £100 per employee. And not only that, but there is a published list of offenders. So there's a list that's been published this week, last week, I think it was. There are 524 businesses on the list so far, and it's going to continue to be updated, this list, of businesses that aren't paying national minimum wage. So you really don't want to be on that list. Okay, let's move on to 1st of April. What's happening then? 1st of April, we've got some holiday entitlement changes for irregular hours workers. Now, these changes will take effect for part year and regular hours workers from holiday years that start on or after the 1st of April. Now, this will apply in your business if you employ 0 hours workers, casual as and when people, part-year workers, for example, those that work school term times. And there will be 2 ways, okay, to calculate holiday entitlement and pay. Right, so the first method is the accrual method. Using the accrual method to calculate the holiday, you would times the number of hours worked by 12.07%, and this is the amount of paid holiday that they're entitled to take. This is based on 28 days holiday per year. We can assist on the calculation if you have more than 28 days holiday per year, including bank holidays. Or you've got rolled up holiday pay, which is currently unlawful under EU law, but will become legal again on the 1st of April. So we used to be able to do it, then we couldn't. Now we're going to be able to do it again. So remember, rolled up holiday pay method, what you would do is pay the employee 12.07% on top of their hourly rate. Using this method, the employee, of course, then is not paid when they actually take the holiday because you've paid it to them in their hourly rate as you've gone along. Now, important to note, if you choose a rolled up holiday pay method, this must be shown as a separate line on the payslip. Okay, so you need to talk to your payroll if they can do that or how they're going to go about managing that. So what are the actions? Okay, and these are really in order of what you need to do. Decide which method you want to use, then consult with your employees, then update the contracts accordingly, and whichever method you choose, contracts will need updating and you'll need to consult with employees, okay, because there's change, contractual change. But we're here to help with all of that. If you want our support, you only have to click the QR code at the end and you'll get lots of offers. What are the risks here? Well, the risks are the employee taking you to employment tribunal and a claim of unfair deduction of wages, of pay. Next, we're looking at the 6th of April now. So this is the brand new Carers Leave. This is a brand new act, okay? It's called the New Carers Leave Act 2023, but it comes into force from the 6th of April this year. It was introduced partly due to the ageing population, okay? And as you know, there is no retirement age now, so beware of any potential age discrimination there. Now, the New Carers Leave Act gives the employee to entitlement to new statutory leave. They will be entitled to request 1 week's leave during any 12-month period. This is an extended right, okay, for all employees to provide or arrange care for a dependent with a long-term care need, okay? It's a day one right to request the leave. So an employee could join your company on the 6th of April and then request the leave, okay? The employee is required, though, to provide notice, so they can't take the leave straight away. Now, the notice must be, crucially, at least twice the leave they're requesting to take. So if, for example, they want to take the whole week of leave, they would need to provide you with at least 2 weeks' notice. Because of that notice, it's not like emergency leave. So in the case of an emergency that the employee had, then they would need to use dependence leave. Okay, they don't need to take the leave in one block either. So they could take 2 days next month and 3 days the month after. Now, this leave is unpaid, okay? If you want to pay it, you can, but we advise you, please don't pay it, because it's going to be difficult to manage, and it's a common belief that it will be very open to abuse. Everyone will eventually start to see it as additional leave. So it's advisable not to pay it, really. The employee is not required to provide evidence that they have a dependent. Okay, so the employee can self-certify the leave and no proof is needed. But the Act does provide a definition of a dependent. So it restricts the scope of this to spouse, partner, child, or parent of the employee. And the dependent may live in the household of the employee or someone who reasonably relies on the employee to arrange their care and their long-term needs. So in that case, it could actually be a neighbour, couldn't it? The dependent is someone with an illness or injury that lasts longer than 2 to 3 months, or a disability within the meaning under the Equality Act, or it's someone needing long-term care due to their age, but it needs to be lasting more than 2 to 3 months. Now, examples might be someone that had an accident on holiday with an injury that lasts longer than 2 to 3 months, or an elderly parent, for example, with dementia or Alzheimer's. Now, employers, they can't refuse carers' leave request, but you can ask the employee to take it at a different time. Now, the employer can only do this if the employee's absence would cause serious disruption to the organisation. If the employer delays it, then they must, this is the legislation talking, obviously, not me. The legislation says they need to agree a date within 1 month of the requested date for the leave and put the reason for the delay and new date in writing to the employee within 7 days of the original request and before the requested start date of the leave. Now, I'm sure that business owners, you're going to feel that this really is quite an onerous new piece of legislation, and it is. And there is a list of actions that you can see on the screen. So the actions are, you definitely need a policy, you need a carers leave policy, or you need to add all of the rules and regulations around this to one of your other company policies. You'll need an HR process for this. You need to keep records. Obviously, our clients using the Breathe HR software, it's good news because we can add carers leave onto the software and update all of that for you in the background of the system. And we need to brief your managers on how to manage the process and, of course, communicate it out to your employees. Now, what are the risks if you don't implement it, if you ignore it, if you don't get prepared in advance of the 6th of April? Well, absences are likely to rise, aren't they? Because that's the other way that they'll get the leave. Absences could rise, grievances, and ultimately you'll get a claim, tribunal claim. There is a lot to deal with here, okay? And remember that the devil is in the detail on this. Right, let's move on to the Employment Relations Flexible Working Act 2023. Now, on the 6th of April, again, this brings about enhancements basically for employees around flexible working and leave. Flexible working, there are lots of different kinds of flexible working, as I'm sure you know, but the term under the Act is really used to describe the agreed working arrangements between the employer and the employee in relation to when, where, and how the employee may conduct their work. So, for example, it might be part-time workers, working from home, hybrid working, compressed or condensed hours, job sharing, annualized hours, and so on. Okay. Make sure that whatever kind of flexible working arrangements you have, and you might have all of those, you've got a clear set of rules that apply to them. For example, do your working from home rules include what happens if the employee has a power cut that day, or their broadband goes down, or the PC breaks, the laptop? What if they're working abroad? Is that allowed when they're working from home, due to your firewall being impacted and the potential tax implications of them doing so? Have you considered this in your policy? If you haven't, get in touch and we'll work with you to write a policy for you. Now, currently, to make a flexible working request, the employee has to have 26 weeks service, and they can only make one flexible working request per year. From the 6th of April, employees will have the right to request flexible working from day one of employment. So no service required at all. And the employees will also be able to make 2 flexible working requests in a 12-month period. Employees also do not have to set out in their request how the employer will manage their workload around the request. And there will be more onerous, it'll be much more onus on the employer to accommodate the request or come up with a suitable alternative. The employer will have 2 months to deal with and respond to the request, including any appeal. And this is a reduction from the current 3 months. So you've got less time to deal with it. But also in that 2 months, you've got more to do, because now the legislation says that the employer, you must consult with the employee about their request and be able to demonstrate meaningful consultation has taken place. So you've got to document that consultation. And again, we can log all of that on the Breathe HR software. If the employee, this is the sting in the tail, if the employee believes that their employer has not handled the flexible working request in a reasonable manner, they will have the right, that's what's written into the legislation, to take the employer to tribunal. Now, there is a list of statutory reasons for rejecting a flexible working request. Please contact us for that list of statutory reasons and we can provide that and talk you through it. So, actions, points for you to take on this legislation. Update your flexible working policy and your HR processes. With these changes, obviously, if you don't have flexible working policies and processes, let us know. We can help you with that. Make sure you've got a documented consultation process, and crucially, that your managers understand how to use it. It's no good it being written into the handbook and the manager doing something else, because it will be the practice that took place that will be presented at tribunal. What are the risks if you don't do it? Well, it'll be a breach. You'll be in breach of a statutory guidance, and there'll be fine at tribunal, which potentially could be unlimited. So not something we want to get wrong. Let's now look at the next piece of legislation. So again, the 6th of April, Protection from Redundancy, Pregnancy and Family Leave Act. Now, this provides changes to the redundancy and family-friendly rights from the 6th of April. If you're thinking of making redundancies, please do take advice. Our clients would always contact their HR business partner when thinking about redundancies, as it's a complex area of legislation and requires really careful management. But this Act now provides additional protection against redundancy for pregnant employees through to 18 months after the birth. This applies to employees who tell their employer of their pregnancy on or after the 6th of April, from the time they tell the employer until the maternity leave starts. But it also applies to employees whose mat leave ends after the 6th of April. So it does apply to people that you've got in your workforce that are currently on maternity leave. In the case of adoption leave, the additional protection period continues until 18 months after the child's placement. For shared parental leave, the additional protection period continues until 18 months after the date of the child's birth or placement. So we really need to know when your workers are pregnant, really straight away, as you know, for all your well-being arrangements and your employer responsibilities in terms of health and safety and protection of them, it's important we know straight away. So do update your handbook policies, saying in the handbook, employees do need to tell you straight away if they are pregnant. They also need to advise you straight away if they move house, change next of kin, and lots of other things. And again, if you have the Breathe HR software, we can automate that and the employees can do it remotely. Do call our team of advisors. We'll guide you through all of these changes, and the actions are on the screen. Update your HR policies, communicate with your employees, and crucially, brief your managers. You really don't want a tribunal claim. That's the risks here. A payout due to discrimination could be unlimited. So, really important that we get ahead of the game on this, which is why we've put this webinar on today. Let's look at paternity leave and the changes, the paternity leave amendment regulation. This is again 6th of April. This is making paternity leave more flexible. Now, paternity leave will be available up to the end of the first year after the birth or adoption of the child. Currently, they can only take 1 or 2 weeks in one block in the first 56 days after the birth or adoption. But from the 6th of April, this will change. They'll be able to separate the leave into 2 separate 1-week blocks and take it at any point after the birth or adoption up to 52 weeks. Okay. Now, currently, they need to give you 15 weeks notice of their intention to take paternity leave. But from the 6th of April, that notice is also reduced down to 28 days. So in terms of managing resources, managing production lines, managing, your business processes, you really do need to start planning and preparing for this now. Actions are updating policies. Lots of policies will need changing. Update the notice requirements and brief your managers. Again, the risks, potentially a claim of discrimination. And of course, the last thing you want is employees coming to you saying, the policies are out of date because I know my paternity leave rights. So as an employer, we always want you to be several steps ahead of the game. In April 2, we've got statutory rates that are proposed to increase. Now, I say proposed, it is still at the moment a proposal, but this is what is anticipated to come in again from April. It's proposed that there'll be increases to statutory shared parental pay, statutory maternity pay, statutory adoption pay, statutory paternity pay, statutory parental bereavement pay, and these are expected to rise 6.7% from £172.48 a week to £184.03 per week, or 90% of the employee's earnings if lower. And then statutory sick pay is, of course, expected to rise again 6.7% from £109.40 to £116.75 per week. The lower earnings limit stays the same at £123 per week. Your HR business partner, if you're a client, obviously will be running through this at your next meeting. If you don't have meetings in your SLA, please get in touch. Let's upgrade so that we can brief your managers appropriately. Actions, we need to update your policies. You need to inform your payroll, brief managers, and of course the fine for any breach of updated regulation here would be £30,000. So, that's not something you want to contemplate. So a recap then on what we've covered today. We've looked at all the changes in the working time and holiday, the right to work checks and all the changes there, national minimum wage, national living wage going up, holiday for irregular hours workers, changes in how we need to calculate that, the brand new piece of legislation, carers leave applicable to everybody, flexible working, redundancy and family friendly rights, and of course, paternity leave. Let's have a look then. As I promised you, we've got another webinar coming up in the next couple of months to look at the next wave of changes, because what we've covered today is only the first half of the year of changes. There's another whole 6 months worth of changes, another at least 10 things that are currently either planned or proposed. The key ones I want to mention briefly are 1st of July changes to the TUPE regulations. So if you're buying businesses, acquiring businesses, selling businesses or parts of businesses, this you need to listen to. The changes allow small businesses with fewer than 50 employees doing TUPE transfers of any size, and businesses of any size undertaking a small transfer of 10 people or less to consult with employees directly if there are no existing reps in place. Okay. We've got a lot of TUPE experience in our team. You do need to contact us if TUPE is going to apply in your business. It's very complex. There's a whole bunch of processes we need to implement to protect you and your business. 1st of July, also Employment Allocation of Tips Act. This is due to come into force 1st of July. This largely will affect businesses where tipping is part of normal practice. So, for example, hospitality sector, and there's lots of you I can see logged on today, hospitality sector, beauty industry, anybody else that tipping is normal practice. This is a new obligation on employers to fairly allocate the tips. It brings a ban on employers keeping tips. So if your pay systems don't include the opportunity to separate tips, you're going to need to start working on this now. Late October, it's expected the Worker Protection Amendment of Equality. That's the new duty on employers to prevent sexual harassment in the workplace. It's an onerous duty. We will cover that in detail at the next webinar. I've already started working on that. October neonatal care leave. This was going to be next year, but it's coming in this year. It's expected in October at the earliest. Stable and predictable work patterns, pension auto-enrolment. We're anticipating the minimum age for enrolment being reduced to 18. Lower earnings limits we expect will be removed or reduced. And the hire and rehire changes to terms and conditions. Non-compete clauses. Lots of clients have non-compete clauses in their contracts. We'll need to review those, as it looks like there's going to be restrictions. And a more straightforward data protection system is also proposed. So that concludes the review of legislation that requires some immediate action. As mentioned, from July, there's a second wave, over 10 areas of change that I'll be covering in the next webinar. You are all invited, so that's the good news. Hang on to the end of the webinar to hear all the offers, and crucially, get the QR code that you need to maximise on those offers. But now we're happy to take your questions. Izzy, over to you.
Brilliant. Thank you very much, Julia. We've had a few questions sent in. So I'll start off with a question that we've had from Graham, who's asked, does this include contractors? And he was talking about the holiday entitlement changes. Jenny, can you answer this?
Yep, sure. Graham, no, this doesn't include contractors. This is only for employees, and contractor is not an employee. They have a contract for services, so the holiday rules don't apply to your contractors.
Making sure, and I'm just going to add there, making sure that the contractors are genuine contractors, and that, you know, we've checked all of that out for you. So
brilliant, thank you. And David has asked, can we still decline flexible working requests?
Yes, you can still decline flexible working requests. There are a number of acceptable business reasons to do that. The change in the rules puts more onus on the employer to, consult with the employer and come up with an alternative if you can't meet it. But there will be circumstances where the request that someone asked just does not fit with your business. So you are still able to do that. You just have to make sure that it falls in line with one of the acceptable business reasons.
Brilliant. Thanks, Jenny. I've got a question here from Sally, who's asked, if my holiday year starts in September, can I make changes to 0-hour holidays from April?
Again, that's a no on that one. That would be, it starts from holiday years that start from April, but you would need to wait until your holiday year started in September. Equally on that, anybody's holiday year that starts in the first part of this year, so from between January and the end of March, they would actually have to wait until 2025 before they'd be able to implement those changes. So their next holiday year.
Brilliant. Thank you, Jenny. Mark has asked, do I have to consult with employees on 0-hour contracts to be able to move them to the 12.07 calculation?
Yes, again, with that one, you would need to consult with the employees, advise them of the changes and what the proposed changes, and then we'd need to make some contract amendments to detail that that's the way their holiday is going to be worked out in future.
Brilliant, thank you. And then Katie has asked, my holiday year started in January. Can I make changes from April? I think you briefly covered that just
I covered that one. So if the holiday year started in January this year, then they would need to wait until January 2025 before they would be able to make the changes.
Brilliant. And I think for the moment, that's all from everybody. Let me just double check in the moderated section. If anybody does have any further questions, we're running out of time to answer them today. Oh, we've just had one come in. Anastasia's asked, is there a limit to flexible working hours?
Not 100% sure what we are meaning by limit to flexible working hours.
You can always go back to her on that.
Yes, I'll make an assumption that it might be a limit to the number of requests. So in the new changes, you can only make 2 requests in a 12-month period. But with regards to hours, they could request anything. So if they're on a current 45-hour contract, they might say they want to reduce their hours to 20 hours or something like that.
Okay, thanks, Jenny. Thank you. I think that's all we'll have time. Oh, Dale has asked one more question. Can you email a copy of the presentation? So after this, you will have a link to access the webinar recording, and you'll get a copy of the slides as well. So Juliet, I'll just pass over to you for one last thing.
Brilliant. Okay. And yes, you will get access to a summary of the changes, particularly if you're a client of Park City. Obviously, we'll go through those with you, and you'll get all the details. But yeah, just to say, you're never alone with Park City. So we're here to help you. We've been advising thousands of businesses over 27 years, giving them the right direction, guidance, and management training. And really what I'd say to you is, do you feel equipped? Are you equipped? Are your managers equipped? And if not, please do scan the QR code that's on your screen now. We've got lots of offers for you today, exclusively for webinar people. And, those offers are on, you won't be able to get to them from our normal website, only from that QR code. So do scan the QR code now before obviously the webinar ends and it disappears off your screen, because again, as I say, you won't be able to get to the offers anywhere else other than through that QR code. Just to say thank you, everybody. I think we're spot on for timing, which is always good. As you know, I'm quite well known for talking longer than I've actually got. So today it wasn't too bad, Izzy. Thank you. But also to say thank you, all of you, for attending. Over 100 of you I can see there attending today. Really hope this was valuable. Really hope you enjoyed it. And look out for your invite to the next webinar in a month or so's time. And we look forward to seeing you next time. Thank you very much indeed.
Brilliant. Thanks, Juliet.
Thanks, Izzy. Thanks, Jenny.
Bye. Thanks.